Welcome back to online classes. Dear students, how are you? Today I am going to discuss with Indian Penal Code. Okay, under section 366A. Section 366A explain about procuration of minor girl. Here the act explained that whoever by any means whatsoever induces any minor girl under the age of 18 years to go from any place or to do any act with intent that such a girl may be, or knowing that it is likely that she will be forced or seduced to illicit intercourse with another person, shall be punished with imprisonment which may extend to 10 years and shall also be liable to fine. This is act. Okay, sorry. Under section 366A was enacted by Act 20 of 1923, okay, to give effect to certain articles of the International Covenants for the suppression of traffic in women and children, signed by various nations at Paris on May 4th, 1910. Okay. While section 366 subclass A deals with procuration of minor girls from one part of India to another. Another means another country. Section 362 subclass B makes it an offence to import into India from any country outside India girls below the age of 21 years for the purpose of prostitution. Okay. Here, as per the section, what are the main ingredients we need to fulfill? So, as per the act explain about the two ingredients is available. Number one, the section requires, number one, inducing a girl under 18 years to go from any place or to do an act. Number two, an intention or knowledge that such girl will be forced or seduced to illicit intercourse with a person. Okay. Here the main applicability of section 366A of Indian Penal Code requires, number one, that the accused, number one means the first, the accused must induce a girl. The second, the person induced was a girl under the age of 18 years. And third one, the accused had induced the victim knowing that it is likely that she will be forced or seduced is induced, okay, seduced to an illicit intercourse. The fourth point, such intercourse must be with that person other than accused. The fifth point, the inducement caused the girl to go there in the place or to do any act. Okay. So, an offence under this section is one of the inducement with a particular object, and when after the inducement of the offenders offers a girl to several persons, a fresh offence is not committed at every fresh offer for sale. Okay, because where a woman, even if she has not attained the age of 18 years follows the profession of a prostitute, and in the following the profession she is encouraged or assisted by someone, no offense under this section is committed by such a person, for it cannot be said that the person who assists a girl accustomed to indulge in promiscuous, okay, promiscuous, that means having a lot of sexual partners, okay, so intercourse for money in carrying on her profession. In this act with intent or knowledge that shall be forced, okay, or seduced to illicit intercourse. And also the accused induced a married minor girl to leave the custody of her mother, and she went with him who married her and had sexual intercourse with her, whose consent she being a minor, who no consent conviction of the accused under section 366A and 376 of IPC was not interfered with this section. However, a sentence of rigorous imprisonment for a period of 8 years under each count was reduced to 5 years. Okay students, based on this section 366A, we'll discuss what is the meaning of seduced and what is the eligibility age and so on. Okay, here what is the meaning of seduced as per this section? The verb seduce is used in two senses. Number one, it is used in this ordinary and narrow sense as including a woman to stray from the path of virtue for the first time. It is also used in the wider sense of indulging a woman to submit to illicit intercourse at any time or any occasion. It is in the later sense that expression has been used in section 366 of IPC and 366A of IPC, which sections partially overlap. The word seduced is used in the ordinary sense of enticing or tempting, irrespective of whether the minor girl has been previously compelled or has submitted to illicit intercourse. A person who merely accompanies a woman going out to play a profession of a prostitute, even if she has not attained the age of 18 years, could not be said thereby to induce her to go from any place or to do any act with intent or knowledge that she will be forced or seduced to illicit intercourse with the meaning of section 366 subclass A of Indian Penal Code. And another part of this in this section, I just wanted to focus the age criteria. Here it is necessary to prove of the age of the prosecutrix to below 18 years. Okay, in this case the school certificate was considered to be the best evidence. About the medical certificate, the court said that it is based on estimate, and therefore the possibility of error could not be ruled out. The age shown by the school admission register was above 18 years. Okay, the court held that no offense under the section was made out. In a case before the Supreme Court, the father of the girl stated that her age on the date of the incident was around 19 years. The doctor also certified the age to be above 18 years. The girl told to court and she was of only 14 years. The Supreme Court said that the High Court did not consider the age of factor fully. The charge failed on the ground of the failure of prosecution to establish that the girl was less than 18 years of age. So the allegations that appellant took the minor girl by force and raped her. Okay. Here the evidence showed that victim girl was a minor. Even if there was a consent of victim girl, her consent is meaningless. Okay. This is what I explained about in the section age factor. Okay. So above 18 years is if any one of the victim person, it is not considering a kidnapping procuration of minor girl. Okay, it is not under in this section also. That is different. Okay, I will discuss with a few small cases where statement and conduct of the victim showed that there was a neither threat nor force used by the accused. It cannot be said that the victim was forcibly kidnapped and kept in custody. Accused is entitled to acquittal. Okay. And another instance, in the case of a young girl was being given tuition by a young boy, they remained in contact with each other if attracted for any relation with this natural also. Any of them may be blamed for legal action permissible by law. Only even in constituting the offence under section 366A and section 366 of IPC or 376 of IPC, there can be no hesitation holding that no offence under any of the section is made out or established or proved in the case. So the order of conviction or sentence is not liable to sustain. Here, merely because a person did not give passive resistance or passive resistance, it cannot mean his helpless resignation on face of inevitable compulsion cannot be deemed as consent. So it is held that only conclusion relevant is that she was kidnapped and kept under barrier and was raped against her will, and conviction under section 366A and 376 of IPC is proper. Okay, non-framing of charges under section 366A, that means offence under section 366A of IPC is not a minor offence to section 366 of IPC so as to invoke section 222 subclass 2 of Criminal Procedure Code. Conviction of appellant under section 366 of IPC without there being a charge is illegal and liable to be set aside. Okay students, and also discuss with a difference between section 366 and 366A. What is the difference between? Here, a bare perusal of the section would indicate that the kidnapping or abduction of any woman with a view to compel her for marriage, etc., is covered by the section. Now, a perusal of the section would indicate that if the minor girl is induced to go from any place or to do any act with the intent that such a girl may be, or knowing that it is likely that she will be forced or seduced to illicit intercourse with another person shall be punishable with imprisonment which may extend to 10 years. Okay. And shall also be liable fine or both. Sorry. The title of this section, procuration of minor girl, that is section 366 subclass A. Okay. The essential ingredient is inducement of a minor girl to go from any place or to do any act with intent that such girl may be, or knowing that it is likely that she will be forced or seduced to illicit intercourse with another. That is ingredient. So the minor must be proved to have been induced to go or to do something. If the charge is under section 366 subclass A of IPC, then kidnapping is not the essential ingredient. While kidnapping, abduction is a part of the offence under section 366 of IPC. Its later part, that is inducement, is the only common ingredient in section 366 and 366A of IPC. That's all. Okay. Okay, students. Now this section is over and we'll discuss with another section of IPC the next class. Okay. Thank you, student. Bye.